Great, thank you. Hello, everyone. It's very great to be here today. I'm Brandy and the lovely Dee Dee over here. Yes, we also have no disclosures, but again, like Dr. Aker said, if anybody wants to pay us more money to do this work, we're very happy to. The objectives of this discussion today is to kind of talk through what are your rights in respect to actions by pharmacy benefits managers. And we really wanted to take the approach to kind of step back a little bit and understand some of the different insurance types and how, what you see in the pharmacy might sometimes bump up against what you hear about is in a law. And it's because insurance codes are extremely complicated. And as in Dr. Aker's talk, they're regulated at a lot of different levels. And I apologize, I'm recovering from a cold a couple weeks ago. So really, let's start with talking about the different plan types and how they are regulated and how that might impact what you see as far as regulation versus what you see in the pharmacy. Like using that insulin example with the cap, even though there's this law that says there's a cap of $35, you could still in the pharmacy see a claim come through where there is a copay that's higher than $35. And that's going to be that differential where it's possibly a plan that's not regulated by the state of Washington, such as a commercial health insurance plan. So our commercial health insurance plans, those can come through your employer if your employer purchases a commercial health insurance plan on the market, and that's what they offer to you. It can also come by actually you purchasing a plan or a person, purchasing a plan on the market personally as well. We have the self-funded insurance plans, and that is when the employer actually is paying for all of the healthcare claims on the back end. So a lot of our large employers are actually providing self-funded plans. Now, when you're in the pharmacy or you're looking at someone's insurance, you don't always know where the funding is coming in on the back end. Occasionally you do. I've seen sometimes in the pharmacy where someone brings in a card that says like they're an iron worker and this is an iron worker union's plan or something like that, where you might know, okay, this is a union plan specifically. But oftentimes, whether you see that card or not, or you're just seeing the claim come through, this is a BCBS claim, but you don't know if it's commercial or self-insured. So oftentimes, unfortunately, when we're actually working with our patients, we don't really know, which is what makes it incredibly difficult to kind of, from our side, being the pharmacist, to work with the Office of the Insurance Commissioner to ensure that these laws are being enforced properly. Then, of course, we have our Washington Medicaid plans, both the fee-for-service as well as the managed care plans, and those are all purchased and contractually managed through the healthcare authority at the state level. I will say that a lot of the provisions I think all the provisions that have been passed into law, protections around pharmacy benefits managers, even though Medicaid is not legally required to have those protections in place, they contractually have adopted all of those protections. So anything that you see in here, even though it's not in the law, it is in all of the contracts that the healthcare authority has with their contracted plans. We also will see oftentimes that the PEB and SEB plans they're kind of managed in their own way. They're really not subject to a lot of the regulations because they really are managing the cost on the back end since they're all purchased also through the state. So ERISA, as also Dr. Akers mentioned, the Employment Retirement Income Security Act is a federal law that really is set out to protect employers and also workers to ensure that there's kind of a base level protection for, it's a lot about pensions, but there's also about what healthcare is provided to employees. So a lot of all those self-funded plans from our employers, they fall under ERISA. So they're protected by ERISA and they do not have to follow the state regulations. They do, however, have to follow some federal regulations as far as what coverage must be included in a person's plan. So there are a lot of things like, for instance, in Washington state, we adopted the Reproductive Parity Act in our state. And so, for instance, a plan has to cover 365 days of hormonal contraception at one time in the pharmacy. But that's, again, not going to apply to an ERISA plan. It's only going to cover like a commercial or state-based plan. So these are some of those things where you see, some of these discrepancies. And then, of course, our Medicare Part D plans, they're all regulated at the federal level. And unfortunately, none of the protections that we put in at the state level can be applied to the Medicare Part D plans. And then, when Dee Dee and I were making this presentation, we spend a lot of time talking about PBMs to each other and to other people. And so we're really familiar with who they are and what they do and the ins and outs of that. But we kind of realized actually after we kind of turned in our slides that everyone, all of our pharmacists and technicians and pharmacy professionals might not be fully kind of aware of what is happening. So I wanted to back up a little bit before we move on and just talk a little bit about pharmacy benefit managers. So originally they were designed to kind of be this person who just handled the adjudication of a pharmacy claim, right? So that instead of a patient having to come in and pay cash and then submit for reimbursement to their insurance company, they would be able to have the claim adjudicated directly in the pharmacy and not have to pay that upfront. Over time, pharmacy benefits managers increased their, I'm putting this in air quotes, services that they provide to the health insurance plans. So they actually are a third party that is contracted to the health insurance plan to design all of the pharmacy benefits. They design the formularies. They work with the pharmaceutical manufacturing companies to work out rebate systems that essentially can earn their drugs, to get on a specific tier within a formulary, those types of deals that are happening. They also determine co-pays on the plan or any co-insurance. And so they really manage the entire design of the plans. So they've really taken on a much bigger role in not only that adjudication process, but the ultimate design of the benefit plan, and so on. However, since they're not the actual health insurer, they have up until the last 10 or 15 years, they have gone completely under the radar and never, ever been regulated. There is absolutely no regulation at the federal level for PBMs. And then in the states, it's really a patchwork of different things that has happened. And it's really, I think some of these started maybe 10 to 15 years ago, but increasingly over the last several years, we're seeing a lot more states trying to regulate pharmacy benefits managers because they play such a huge role in our healthcare, the healthcare costs to the patient, as well as healthcare costs to the state. So I'll probably try to talk a little bit about spread pricing, for instance, which has been actually against the law in Washington state Medicaid, but it's found in several states. You can just actually do a simple Google search and you'll find that in Ohio, as well as Florida, many claims have been assessed, and they find that PBMs frequently, they tell the health insurer, we paid the pharmacy $500, for instance, for this drug. But in reality, they paid the pharmacy $250 for that drug. So because they're in the middle, they end up keeping the rest. And that's that spread pricing piece. So there's a lot of different regulations that have gone into effect in different states trying to get at some of these different antics, we'll say, that pharmacy benefit managers have played to really take a lot of money out of our healthcare system. So when the laws that we're kind of going to be talking about here, and Dee Dee will get into in a minute, were passed and went into, and have just most recently went into effect, that was before the Supreme Court case, Rutledge versus PCMA. So Rutledge is the Attorney General of Arkansas, or was. PCMA is the Pharmaceutical Care Management Association, so the association for all the PBMs at the national level. And in 2016, Arkansas passed a law trying to regulate PBMs in lots of different areas, but one of the key areas was on reimbursement. And they specifically said, look, PBMs could not reimburse a pharmacy less than the pharmacy paid for the drug. That it just doesn't work. It doesn't make sense. It doesn't, there's no sustainability in that. Ultimately, there were lawsuits at the state level that went all the way up to the Supreme Court, and Rutledge won that Supreme Court case. So the Supreme Court said states can regulate ERISA plans around reimbursement specifically. So that's a really great thing. We unfortunately have not in Washington State been able to get to that point where we're regulating ERISA plans on reimbursement, but we now can because of that Supreme Court case decision. So in some of the laws that we're talking about in RCW 48.200, the exemptions are all for the PEB and SEB plans, any union plans, so a plan administered for and by union members. Medicaid, of course, except like we said, most of the provisions are there contractually. And then nothing, for Part D again, because those are all federally regulated.
All right, it's my turn. So as we were, we've the past, since 2014, looking at pharmacy benefit managers and attempting to regulate them, we've got some audit standards in law. So PBMs must establish a written process and procedure for a pharmacy to appeal claims findings and must provide notice to the pharmacy prior to conducting an audit. PBMs may not conduct an audit of a claim more than 24 months after the claim was adjudicated by the entity. Must give pharmacy 15 days advance written notice of an on-site audit. May not conduct an audit on site during the first 5 days of any month without a pharmacy's consent, and must conduct the audit in consultation with a licensed pharmacist if the audit involves some form of clinical or professional judgment. May not conduct an on-site audit of more than 250 unique prescriptions of a pharmacy in a 12-month period, except for cases of fraud. You have Oh, thank you. And so, what's a validation of a claim? It's an electronic or physical copy of a prescription, a valid prescription, if the prescription was within 14 days of the dispensing date, picked up by a patient or designee, delivered by the pharmacy to the patient or designee, sent by the pharmacy to the patient by a United States Postal Service or other common carrier, point of service register showing purchase, and electronic records, including signature logs, scanned or stored patient records, or any other documentation that corresponds with the claim. To continue, PBMs cannot conduct more than one on-site audit of a pharmacy in a 12-month period, must audit each pharmacy under the same standards as those similarly situated, and must pay any outstanding claims no later than 45 days after the date the appeals are concluded or the date a final report is issued. They cannot include dispensing fees or interests in the amount of any overpayment assessed on a claim unless the overpaid claim was not filled correctly. They cannot recoup a cost associated with any clerical errors or other errors that didn't result in any financial harm to the entity or consumer. And they cannot charge a pharmacy for a denied or disputed claim until the audit and the appeals procedures are final. And then we get to the reports. The PBMs must provide pharmacies with a preliminary report within 45 days. Pharmacy has 45 days to contest. There are extensions that can be considered, and there is the allowable, you can resubmit of claims denied or disputed for reconsideration. And then the PBM must provide the final report 60 days after its preliminary report. If the identified discrepancy for an individual audit exceeds $40,000, any future payments to the pharmacy can be withheld by the PBM until the audit and the appeals procedures are final. So Brandy's going to talk about the fees and activities.
All right, so really this was a big part of 5601 and that is now in the law and actually just went into effect in January 2022 because it takes quite a while for the plan time to turn over. So usually when a law passes about an insurance plan or what's contractually required, it has to go into effect usually at least 1.5 to 2 years later. Sorry, because they have to actually create the new plans and then be able to implement them in the upcoming plan year. So some of the provisions are around, PBMs, some of the things that they do, they are able to communicate directly with patients, the patients that they serve through the health plan. So we really want to make sure that they're not knowingly advertising or promoting in a way that is misleading. We already know that patient steering is a huge issue, and that's what we were trying to solve during this most recent legislative session that unfortunately didn't get passed. But besides where there is oftentimes required patient steering to a mail order, all right, but there is a list specifically in statute that provides some specific things they cannot charge a fee for. And then also there's a good description. So really trying to get at describing ways that they can't charge fees, even if they call it something else. So they can't charge a fee for an adjudication of a claim. There's also a description in here about, they can't charge any fees related to processing of a claim. So even if they try to call it something else, we're trying to get at the fact that they can't charge a fee for us to be able to serve their patients, which requires, of course, a claim to be adjudicated.
I've definitely been hearing from independents who are looking at their fees and seeing fees, and we're aware that this may not be being enforced at the moment. And so we're working on how we challenge that and go forward and work with the Office of the Insurance Commissioner. So I know that the reality of what you see may not be what this is at the moment, and it just started being implemented. So we'll play whack-a-mole.
Yes, and definitely if you are privy to seeing what's in your contracts or what fees are being charged to the pharmacy, reach out to Jenny and Dee Dee, and they're trying to gather information so that they can work with the Office of the Insurance Commissioner and try to figure out how this can be enforced. So, communicating along, with our community is a really good thing here. But really trying to get at that the PBM shouldn't be charging the pharmacy for participating in the network or accreditation or anything like that. Sorry, I lost my pointer here. All right. They also cannot require accreditation standards that are inconsistent with or more stringent than accreditation standards by a national accreditation organization. And this comes about because oftentimes PBMs were putting onerous accreditation requirements on pharmacies far beyond what is recognized professionally at the national level or a state level. So trying to kind of protect pharmacies from having to pay a lot of those additional fees that also often go along with those higher accreditation standards. PBMs may not reimburse a pharmacy in the state in amount less than they reimburse their own affiliate for pharmacy services. And this is one of those things I told you there's been many reports out of Ohio and Florida where they've actually done Freedom of Information Act requests. And like in Florida, they looked at 350 million de-identified Medicaid claims. And they find time and time again that the PBMs are reimbursing their owned pharmacies. As previously stated, they frequently are steering patients to those pharmacies. They'll pay them 10 times plus what they pay a local pharmacy, especially independent pharmacies, has how those reports showed. So really trying to get at that and making sure that they are reimbursing our local pharmacies and pharmacists adequately and the same that they reimburse their own pharmacies. Again, this is one of those places where this could be applied essentially to the ERISA plans based on the PCMA court decision, but we're not there yet. So more work for everyone here to be doing. They cannot basically claw back. So directly or indirectly, retroactively deny a claim or reduce a claim. So those clawbacks, they cannot do clawbacks. Unfortunately, this doesn't touch DIR because that's Medicare Part D. So that's definitely a bigger issue for us all to be involved in. There is a proposed rule for Medicare Part D and DIR fees right now. So definitely keep track of that, and we'll keep working on that at the federal level. And then really just trying to get at that they can't take anything back unless it was for some reason that was a fraudulent claim or there was an audit involved and money was taken back because of that.
Okay, so I'm going to talk about other contractual requirements in addition to everything that we've been talking about. As we were looking at drafting our legislation over the years, and we'll talk about all the 3 bills that we've been working on, it was really important to address the PBMs and the lists that they provide to you folks and the pricing lists. So a PBM may not place a drug on a list unless there are at least 2 therapeutically equivalent multi-source drugs, or at least 1 generic available from a manufacturer that's generally available for purchase by network pharmacies from a national or regional wholesaler. Because what we were finding is when businesses were pushing back, when pharmacies were pushing back and saying, hey, this reimbursement isn't fair, and they're like, well, we have it on our list, and the list would come from Tennessee. And so we really narrowed this language down that says you have to have a list that the pricing applies to Washington pharmacies. And then shall ensure that all drugs on the list are readily available for purchase by the pharmacies who operate in Washington and who get their drugs from national regional wholesalers that serve those in Washington, and the drugs cannot be obsolete. Let's go next. So additional contractual requirements. PBMs shall make available to each network pharmacy at the beginning of the term of their contract and upon renewal of a contract, the sources they use to utilize to determine the predetermined reimbursement costs for multi-source generic drugs. Now that's a mouthful. And we initially, when we put our first bill together, we were looking at using MAC, the maximum allowable cost. But what we've learned over the years is that the pharmacy benefit managers are very sly, and they find loopholes and they find workarounds. And so we tried not to specify MAC in general. So we came up with predetermined reimbursement costs for multi-source generic drugs. So you're going to see that throughout the PowerPoint as we refer to these lists. PBMs shall make a list available to the network pharmacies upon request. They must update each list the PBM must update the list every 7 business days and make those updated lists, including all the changes in the prices of the drugs available to network pharmacies. And they cannot include dispensing fees in the calculation of their reimbursement costs. Okay, so appeals process. So as as we were dealing with this, the pharmacies were talking about, hey, how do we do this appeals process? The PBMs all have these different various appeals. Some don't even have it. So we created in law that a PBM must establish an appeals process for network pharmacies to appeal its reimbursement for the drug subject to the predetermined reimbursement costs for multi-source generic drugs. A network pharmacy may appeal the reimbursement for a multi-source generic drug if the drug was less than the net amount the pharmacy paid to the supplier of the drug. So if you were getting paid less than what you bought the drug for, you could file an appeal. The appeal must be completed within 30 calendar days of its submittal. And if after 30 days, the network pharmacy has not received a decision of appeal, has not heard back from the PBM, the appeal is considered denied. So then we were looking at, okay, so let's have a second tier. Okay, we're appealing to the entity that is they can just ignore us. And so there was no other, other option. And we started out this appeals process to apply to all pharmacies in the state. But as politics and how things work out, they said, listen, okay, if you guys want to do this, let's apply this to small pharmacies. So we created the small pharmacy reimbursement appeals. So the small pharmacy reimbursement appeals can be submitted to the insurance commissioner office by their website, requesting the insurance commissioner to review a PBM's decision regarding the reimbursement of a drug, as long as the appeal is filed by a pharmacy that has 14 or fewer outlets in Washington, the prescription was filled in Washington, the prescription was filled for a patient covered by a fully insured non-ERISA plan, the prescription was for generic multi-source drugs, and that the small pharmacy had utilized the PBM's initial reimbursement appeals process. So they had to go through the PBM's appeals process in order for the second tier to kick in. And the pharmacy had been issued a denial or it was unsatisfied with the reimbursement for the cost of the drug overall. So then we had to set up this process, and Brandy's going to go into how to file, but eligible, kind of just going back, eligible pharmacies can submit information to the insurance commissioner office about an appeal. So we put this under the insurance commissioner's office because they oversee all the carriers, the health plans, these guys, it just made sense for these guys. At first, they didn't want it, and I'll talk a little bit about that, kind of the evolution. They didn't want this, but when we passed this bill, 5857, that created the small pharmacy reimbursement appeals process, we took the opportunity to educate the insurance commissioner's office on PBMs. They didn't know they even existed. And here you have an entity that is making, basically setting the cost of prescription drugs, impeding access, and really impacting consumers. And so we took this opportunity to use it as an education process with the insurance commissioner's office after we passed this law that directed the insurance commissioner to create this process. So the commissioner authorizes the Office of Administrative Hearings to conduct review of the appeals process. And if it's upheld, the PBM shall make a reasonable adjustment within 1 day after its determination. And then we had to put in, PBM can't retaliate against a pharmacy for pursuing an insurance commissioner review of appeal. I mean, we've had to put in these, again, we had to put this in law because these guys would, they would harm an independent pharmacy in retaliation for filing a complaint. So we had to put that in law so we could hold them accountable. And then Brandy's going to talk about how to file a small pharmacy reimbursement appeal.
Yeah, so you can access this link actually through the documents that are shared via Lecture Panda. But also if you just Google Office of the Insurance Commissioner, Small Pharmacy Reimbursement Appeals, you can find all this information and the link to actually file the petition there and kind of read more about the process. So it has to be an acting representative of the pharmacy. And so that's either a manager or it could actually be a person who is a legal representative of the pharmacy. And then before the appeal is even filed, really all of the documents need to be gathered. So make sure that you get everything that was a part of the original appeal to the PBM, the invoice for the drugs, the MAC list, the current MAC list for the PBM is required as part of the appeal. Their determination. So as Dee Dee said, if they don't respond in 30 days, that's also a determination. So just documentation showing that you filed the appeal was filed, but it was never responded to within the appropriate time frame. And then what's really important, what we've heard from people who have been successful with these appeals, is really the other support documentation. So showing, contracts with secondary wholesalers, for instance, citing that if say on the MAC list, even though they are supposed to only have drugs on that list that are accessible to pharmacies in Washington state, we actually find that that's not always the case on the list. So the people who have been very successful with these small pharmacy reimbursement appeals is that they're able to show, through their main wholesaler, they're not able to buy the drug at that cost. And then also even through a secondary wholesaler, maybe the drug alone could be at that cost, but the extra fees, because they're a secondary wholesaler or something, would actually increase the cost of acquisition overall. So any documentation that you have that can really make your case for why the acquisition price is more than what they're allowing is going to be really, really helpful in the case overall. And then submit all the documents. I heard from some pharmacists that it wasn't really clear at certain points during the process what documents to provide when. Provide all of the documents at every step. So when you file the petition, like through this link, or once you go to the page on the Office of the Insurance Commissioner's website, there will be a place to submit documents there. And then you'll be contacted by the Office of Administrative Hearings from the state of Washington. It's actually an administrative judge who oversees the hearings and makes the determination. So at that point in time, when you get contacted about having a hearing, also submit all of your documents again at that point in time, just to make sure you're closing the loop and that the judge who's making the determination has all of the information that they need to be able to make the determination, hopefully in your favor. So the judge reviews all of the documentation, and then they also will have a hearing where you will get to come join the hearing, of course. From what I've heard from many pharmacists who have also been successful in this, the PBMs don't always show up. So that gives you the chance to show up and make your case, hopefully really well. And one of the things with this, especially if, say, on that list, on their MAC list, if they did have that drug from Tennessee that's from some wholesaler that you can't get in Washington state, in the WAC that actually goes along with these laws, there is the enforcement mechanisms of fines. So a fine of $1,000 every time that a PBM is not following the law. And it could actually be up to a $5,000 fine if you're able to show that they willfully and knowingly did not follow the law. So each time that one of these is filed and it's successful and they're doing something wrong on their end, like not putting the right drugs on the list, that could end in a fine for them. And we really want to work with the OIC and make sure that we're really showing that the PBMs are acting in bad faith and they're not following the law, because this can hopefully help our case going forward, as we really need to build more regulations around PBMs to protect our patients, as well as to protect pharmacists and pharmacies in Washington state. There's also a new provision where we can actually file complaints against PBMs for, not an appeal to actually get more money from them, but just complaints that they're not following their contracts. And it's a little bit unclear right now about what that process is going to look like. However, part of the law that just went into effect in January is that PBMs must file all of their contracts with the Office of the Insurance Commissioner. So that's their contracts they have with both the health insurance plans as well as with each individual pharmacy. So if you can file a complaint, and hopefully that process will be up and running soon, but the OIC could actually go and look at the contract themselves and possibly be able to make determinations on if the PBMs are following their contracts. And ultimately, my hope is that eventually they can start seeing patterns of unfair contracting, because oftentimes we know that, the pharmacists and pharmacies don't really have much say in the contracts and what is actually in them. And now Dee Dee is actually going to walk us through one of the, I think, really important parts of kind of understanding this bigger picture is how we've gotten from point A to point B to point C and actually built some regulation around the PBMs.
Yeah, so, I started tackling pharmacy benefit manager legislation back when I was with the Retail association. 25% of my time was spent overseeing a retail pharmacy council. And they quickly brought it to my attention. I quickly learned about the pharmacy benefit managers. And we started running, that's when we first started running legislation. And our first bill was any willing pharmacy provider legislation. And we focused on that when I think we ran a light touch on mail order. But what we learned, and it was tough because our focus was on the health plans at the time. We were trying to get at the PBMs through the health plans. And we were unsuccessful. And then so we finally realized, okay, we need to start drafting our legislation that's specific towards the pharmacy benefit managers. And so this is where, the challenge has been, and, we're making progress, but it was really hard to explain to a lawmaker what is a pharmacy benefit manager and what's their role. The carriers and the PBMs really enjoyed the fact that, trying to explain the PBM's role, because it is so complex. Pharmacy is complex, reimbursement is complex, drug supply chain is complex. And so they really took advantage of that for several years. But the first bill that we were successful in passing in 2014 was in Gross Substitute Senate Bill 6137. And this established the PBM registration within the Department of Revenue. It created the audit standards I gave you the review over, and establishing the MAC lists and the updates and notification and transparency requirements. So we initially wanted the PBM to be within the Office of Insurance Commissioner, but at the time they didn't know who they were, they didn't want it, no agency really wanted it. So the lawmakers decided, okay, let's just put it under the Department of Revenue. So fast forward a couple years, the PBMs were just ignoring it because there really wasn't any enforcement. It was like, okay, we got to file a registration and pay $200. Okay, and some of them just didn't do it. So we went back to the lawmakers, and lawmakers don't like to pass bills that people ignore. And so we just went back and said, hey, listen, these guys aren't doing it. The insurance commissioner's office at that time, we had started having conversations with them, educating the insurance commissioner's office about these guys and said, hey, you guys might be really interested in this. And so they agreed to say, okay, move the registration over. So we introduced 5th in Gross Substitute Senate Bill 5857. And I want to point out the 5th in Gross Substitute Senate Bill. That's a first in Washington State, a bill that was amended 5 times on the Senate floor. It was quite a battle. But what we did was we moved the PBM registration over to the Insurance Commissioner's office. We established the small pharmacy reimbursement appeals process, made some changes to the MAC and updated the multi-source generic drug definition to the appeals process. And then we started putting some teeth into it. We allowed the OIC to financially penalize the PBMs if they were found in violation of a claims reimbursement. And this is under the small pharmacy reimbursement appeals process. So we put that together, and during the interim, when the insurance commissioner's office was creating the small pharmacy appeals process, we put together a group of WSPA members, pharmacy owners, who came down for an entire summer and met with the insurance commissioner's office to talk about and help them create this process. They also met with the PBMs, but we took this opportunity to start telling them and educating them about the PBMs and about their role and the significant impact they were having. And so it really caught their attention. And so, we're moving along with 5857, trying to make sure that, people were aware of the small pharmacy reimbursement appeals process, but still running into issues with the PBMs overall, because the OIC had limited authority, and it was really over the small pharmacy appeals process. So as we were, we caught the attention of the insurance commissioner's office. A group of other, lobbyists came to me who represented several provider groups and said, hey, there's other healthcare benefit managers out there that are similar to the PBMs. I've watched you over the years try to fight these guys. Do you guys want to come together and create a coalition and approach this in a broader way? And I said, absolutely, because for years, it was just the pharmacy association. It was pharmacy against the PBMs, and it was just a battle royale. And we were just making small steps. We were making steps, and that's the good thing, is we were getting things passed and things in law. that we were able to refer to, but it was real important. I mean, there was more to do. So we created, WSPA co-led this, was co-lead of this coalition. We worked with the Insurance Commissioner's Office. They provided technical support, and we created Senate Bill 5601. So as Brandy alluded to, this bill, we created the definition, it's the first of its kind in the country, healthcare benefit managers, to include PBMs. And so it provides, we gave OIC clear authority over certain PBM practices, requires carriers and the PBMs to file all their contracts with each other and providers with the OIC, and then prohibits, as you saw, some specific PBM practices. So we've essentially moved all the PBM laws into one chapter of law. We still have some work to do. We've just, we've discovered some definition issues, and this isn't over, but we have something to work off of. We've got a baseline now, and so we'll continue to work. We continue to hear from our members that this is a big issue. Their livelihoods are at stake. The PBMs completely unregulated on a federal level. Washington State was one of the first to pass the registration. And a number of states are starting to do, as Brandy said, just kind of a patchwork approach, because we can't wait for the feds to do something. We've got to do something on a state level. So we've got some more work to do. We'll continue to do the work, but this is what we have right now to work with. And, we'll just continue to just try to fight this fight with these guys. Are we running out of time? Okay.
Yes.
Sorry.
Sorry, we can talk
But
about
there
this
is
all
some
day.
self-assessment questions on there that Mylyn will launch. And I swear we could talk about this all day long. One thing that I think is important to highlight as we talk about workplace wellness and pharmacists and taking care of our pharmacists and our pharmacy staffs, the PBM regulation ties to that in our mind. Pharmacies are not being paid adequately for providing the safe, essential care that they provide. And we have to make sure that that reimbursement is in the right place, reinforced in the right way, so that we can staff in a safe way, so that we can support our pharmacists. I don't think that fixing the PBM laws alone is going to fix where we're at, but I think it's an important element. You sure aren't going to get more staffing if you don't fix the payment issue and the reimbursement issue and make sure that that's in the right place. So that's why this is so important to us. From the business of pharmacy, it ties to patient care, it ties to patient safety, it ties to pharmacy staff, our pharmacists, our pharmacy technicians, interns' well-being in our mind very directly. So I just wanted to highlight that. Thank you, Dee Dee, for going to bat for us in Olympia year after year. You're a tremendous asset. I know this year was rough and we really appreciate it. Brandy, we're missing you already, but wish you the best luck. And we know you're not far away in Alaska, and we'll be continuing to be a partner in some of this work. So
Thank you.
thank you both. The code for this section is gardenia. I will write that out. Gardenia, gardenia is the code for Lecture Panda. Gardenia,